Richard Green, that's Green. Testified about 24 times in various state and federal courts.
And so we're doing all of this to try to be as efficient as possible to avoid.
Karenread's expert witnesses are targeted once again by the Commonwealth of Massachusetts prosecutors. Why?
The prosecution is doing everything in their power to leave the defense without any experts. I'm Lainey Law.
And I'm attorney Andrew Myers.
And is this normal procedure in court?
There's nothing normal in the Karenread case, as I think you know by now. When Special Prosecutor Hank Brennan came into the case, he said he was going to try and make it more efficient. He's not bringing in anything new yet, but he is trying to pick off all the expert witnesses. Most recently, the forensics guy, Richard Green, I shouldn't call him a guy, he's the expert who took a look at, the famous Jennifer McCabe 2:27 a.m. search, Haas Long to die in the snow.
Do you have an opinion as to the timing of that first search for Haas Long to die in cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
He also said that McCabe did try to delete some stuff from her phone, and that's crucial to Karenread's case. So now a motion was filed to try and exclude Richard Green. So if they are successful, it would punch a big hole in Karenread's defense. The motion had some pretty strong language. Now, let's bring it in. Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. Now, I don't know. I never really thought much of the word debunked. As you know, I don't like people saying. I don't really think it's really. I mean, it's in the dictionary, but I think it's a child of the internet, don't you?
Well, I can see where you're coming from with that. I think of Mythbusters almost when I think of debunked, though. But it sounds like it's coming off pretty strong, and that's interesting to see.
Anytime you say anything on the internet, if somebody doesn't like it, they'll say, "Oh, that's been debunked," and that means nothing.
Yeah.
I mean, it really. I mean, the definition of the word does in fact mean that someone has disproven it. But I think people are too quick to use that word.
Debunked.
So
probably never looked up the definition of the word in their life.
And it's in this motion a couple of times. Let's take a look at the date stamp up at the upper right-hand corner. This was filed on January 2nd. And the Commonwealth respectfully moves the Honorable Court to exclude the proposed expert testimony of Richard Green relative to the two issues. The claim that Jennifer McCabe's phone Googled how long to die in cold or Haas Long to die in cold at any time prior to 6:23 on January 29th, and that Jennifer McCabe's phone incurred user deletions of any data related to the Google searches. So that's the basic thrust of the motion.
Mm-hmm. But it is interesting that he would try to deny also the deletions of any data related to Google searches, because you would think that would be something that is pretty clear cut.
Yeah, you would think so. Basically, what they're saying here is our expert's smarter than your expert. Look down at paragraph 3. The Commonwealth's expert, Ian Whiffen, celebrates senior digital intelligence expert and an expert in digital forensics. My understanding is that Whiffen is more of a salesperson for the company than an engineer. But
oh my gosh.
After a comprehensive study of the forensic data and consideration of Mr. Green's claims, Mr. Whiffen's opinions disproving Mr. Green's claims are unequivocal. That's pretty strong language when, Mr. Green was on the stand for some time at day 29, and he testified after being qualified Mr. Whiffen provides, I can state with absolute certainty that there is no evidence whatsoever on this device that the Google searches how long to die in cold or how long to die in the cold occurred prior to 6:23 on the 29th of January. That's pretty strong language. And, it's rare that somebody can testify with absolute certainty. So Hank Brennan has dug a big hole for himself that he better fill up if there's a hearing.
Yeah, so I guess I'm just, a little taken aback at how this is an issue of contention, where how is there not just the simple of solution of going through and just identifying what those key factors are that would identify had this happened at what time, at what point? Because I know we talked about like when the tab is open versus when the search occurred,
Right.
but even just like on your Google account, you should be able to see what searches you make when. It should have your history. And if that's the case, and if that's what they're saying, like that's what they deleted, hello, I don't know. That seems like a red flag to me.
Yeah, and it seems to me that you engineering types should be pretty easy to figure that out.
That-
I mean, I wouldn't know what to do.
I would know where to start. How
So-
many people are deleting their history?
Yeah, I wouldn't even know how to do that. But they're saying that he fails to meet the requirements for an expert, which the federal case is Daubert and the Massachusetts case is Lanigan. And Mr. Brennan is claiming that Mr. Green fails the test of those two cases because, one, the defendant cannot meet its burden to demonstrate that Mr. Green is qualified to testify, and two, Mr. Green's opinions do not meet the minimum requirements of digital forensics and lack of any scientific basis. Three, Mr. Green will be unable to provide any facts to support his previous testimony, which has been completely discredited relative to these two issues. And again, the prosecutor is digging himself a pretty big hole because that is a somewhat subjective standard that he didn't provide any facts. He did provide facts, but the motion goes on to say that Green had submitted an affidavit on behalf of the defendant, opining that the search history information obtained from Jen McCabe's cell phone indicates that on January 29th, 2022, at apparently 2:27 a.m., the phone's user entered the following search in Safari: Haas long to die in the cold. And now we know that people have T-shirts and stuff like that. And, the question is, if it happened at 2:27 a.m., why is Jennifer McCabe making that search? They're twisting things around, the Commonwealth is, to try and say that it happened at 6:27, to say that she didn't do it earlier. In response to Mr. Green's misconstructions, the Commonwealth retained two experts in digital forensics, not one, but two, Jessica Hind and Ian Whiffen. During the defendant's first trial, the court permitted a courtroom demonstration by Mr. Whiffen to assist the jury in understanding digital forensics and how the Google searches were stored within the digital databases, specifically the Safari internet browser.
And that's, to me, like where it should be extremely clear. I do want to say is just like, for those of you that are watching who may not know this, every time you do something on the internet, that information is saved, whether it's on your phone or whether you're a Samsung user or whatever. Unless you're specifically going out of your way to not have these searches available, there is a very clear timeline of when a page moves to a next.
So the Commonwealth's trying to muddy that timeline up. Their expert, Jessica Hind, a highly qualified forensic examiner, conducted an encompassing review of digital artifacts, file systems, and conducted independent peer review experiments to determine that Jennifer McCabe's phone was in use at 2:27 a.m. when the Safari browser was open and looking at a website for a Hakomic sports event. At 6:23 a.m., the same Safari browser tab was engaged and a new search for how long was conducted when Apple produces a suggestion for how long to digest food. The search is instead completed with how long tea die in cold at 6:23 a.m. A new search is conducted at 6:24 a.m. of Haas long to die in the cold. So this is a battle of the experts, although the Commonwealth is going to try and convince us all that it's not. Argument. Richard Green's debunked. There's that word again. I mean, that's
He
an
likes
interesting.
this strong verbiage.
It's an internet word. If you say any, how many times have we been told, "Well, you've been debunked"? It's just something people throw out there if they don't have anything intelligent to say.
Mhm.
I've never seen the word debunked in a legal brief. I'll just say that. Richard Green's debunked opinions are not an example of a battle of the experts, best left to be resolved by the fact finder, but instead an attempt to infect the jury with an inadmissible opinion that is not premised on reliable digital forensics. Celebrite has updated its software to prevent manipulation of data. Shortly before the defendant's first trial, Celebrite continued and introduced Physical Analyzer software version 10.2. Since the defendant's first trial, Celebrite has added another version of updated software 7.67. The updated version removed the timestamp value from records sourced from the Safari's browser state DB because further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. What? Does that make any sense to you?
No. I'm trying to process what this is saying. The updated version removed the timestamp value from record source from the Safari's browser database because it shows that timestamp is not a reliable source for a timestamp relating to the URL shown. So it's from this, the only thing that I'm obtaining is that they were saying that their software had incorrect, irrelevant information is the only way. They're just it was bad, so we fixed it. And if you're telling me that it was doing something incorrectly and attributing unrelated information in the first place, how am I going to trust anything from Celebrate?
It's just like one of those things. Like, I hate my Apple iPhone. Apple iPhone engineers, you're so smart. If you're so smart, why does it constantly update itself all the time? Why is it always? And in the old days, you could put it off. But now they force these updates. And so are you saying that everything that Apple ever did before my last update last week was crap? Is that it?
A lot of the times, honestly, it is, because a lot of these forced updates that they're putting on is oops, we got hacked, oops, we got breached, oops, exploit. So this is just what this is telling me is that whatever the software is, Celebrate, that they didn't do a good, they were giving you bad information in the first place, in which case, where's the credibility in any other, I don't know.
I think the timestamps, they can't say that those were off because that means everything has been off, since day one. It goes by the, what do they call it? The international global clock, and everything is timed into that. We no longer turn our clocks ahead and back because our computers do that automatically. And all that stuff is tied into that. And I don't think it has anything to do with Celebrate. I don't think it has anything to do with an update in the software, but that's what they're trying to say. Reading between the lines, they're trying to say that Mr. Green, he was using the old software and he refused to update his records. And so
he was just reading the number that was given to him on a screen by the software that he was meant to trust.
So here's that word debunked again. Let's use that word as many times as we can. Inadmissible evidence should always be excluded. Allowing debunked claims to reach the jury would necessarily risk misleading the jury and creating prejudice to the Commonwealth. So I don't think this is an issue, as Mr. Brennan says, of admissibility. There are two different things in evidence. There are two different things. Whether any piece of evidence, whether it's documentary or a film or demonstrative or something like this, whether it's admissible, and that's a gatekeeper function. Should it get in? Should it not get in? Then once it gets in, the second question is it relevant? And I think Mr. Brennan is trying to say, Oh, no, it's not an issue of whether or not it's credible. He's trying to push it forward to the first test as to admissibility. The role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. Mr. Green's factually wrong opinions would not assist jurors and would instead risk confusing jurors.
Well, I'm already confused on what the point of this is. So like, so fair, because I don't know, the whole saying that the timestamps are incorrect. I think that is a crazy can of worms to open.
Yeah, it is, because I think some of the Commonwealth's testimony was based on some of the same problems. So the law is that an expert witness is not permitted to testify to matters beyond an area of expertise or competence. Now, by the way, I believe that Mr. Green had testified in something like 2,000 trials before. So to say that he doesn't have expertise to testify in a trial, flies in the face of those 2,000 other judges that said yes. Times when other judges, 2,000 times when other judges said, yeah, he's credible. And also, same question as we had when we covered the first hearing. And by the way, the second hearing is coming up as to the Daubert hearing for Dr. Marie Russell. Is Beverly Cannoni going to reverse herself and say, oh, I was wrong to let these people in. I was wrong to let these people in. Is she gonna, because she really kind of has to say that.
Yeah, that's an interesting point that you make. And because I agree with the saying like those other however many judges are wrong. And then also for her to say, you know what? Yeah, like, oopsie, why did I let that slide the first time?
Do you know what this reminds me of? I have something like 9 credits in propaganda studies in college. And one of the top 10 methods of a propagandist is to repeat the lie, repeat it until people hear it so many times they think it's true. So, clearly the methodology or theory underlying Mr. Green's testimony is not sufficiently reliable. It's not reliable. It's not reliable.
It's been debunked.
So it's been debunked. So you repeat that he's wrong and that he's been debunked till, the reader of this motion is going to come away, a reader of this motion who, hasn't gone through trials and understood what's going on. The reader of this is going to say, oh, wow, he's wrong. So what does Mr. Brennan want? For the foregoing reasons, the Commonwealth respectfully requests that the court order a Lanigan hearing or exclude Mr. Green's opinions relative to the 2 contested claims at trial. So you know what the real issue is here? I kind of touched on it in the introduction to this episode. I think, in my opinion, the real issue here is that the Commonwealth is mad as a wet hornet's nest that they didn't get their conviction the first time. They're furious, and it's pretty much been described to me in that manner by some people I've talked to behind the scenes who don't want to be identified. They're just mad. Another analogy is they're mad as a wet hen. They're furious. They're just absolutely downright furious that they didn't get their conviction the first time. But rather than come up with new evidence, which, if they're going to, where is it? Rather than coming up with new evidence to support their own claim, they're just nicking away at the defense. They demanded that there be a new Daubert hearing for Marie Russell. They're going after Richard Green. And there are inklings that they're going to go after the ARCA experts. Mr. Brennan has filed some discovery requests for a lot of information underlying the ARCA experts and their background and experience and all that kind of stuff. So they're really, rather than coming up with anything new, they're just really taking a shot at everything that Karenread has done in her first trial. So,
which doesn't really look good for them, honestly, because it already didn't end well the first time. And then just as an institution, there's these claims of cover up. And so then now, instead of introducing anything different or anything better, they're just trying to take away the parts that they didn't like. And I don't know how that's going to work this time around in such a public case.
And one thing that, sticks in the back of my mind, and a commenter a couple of weeks ago actually pointed it out during the Marie Russell hearing, At some point, the district attorney's office, if not the district attorney himself, had alluded to the fact, this goes way back before the first trial, had alluded to the fact that we have video of Karenread's Lexus backing into John O'Keefe. Well, that video never came out at the trial. Where is it? Where's that video that was promised? And also,
if it exists.
yeah, well, obviously, in my view, if it existed, wouldn't that have been Exhibit A in the case? Here it is. We don't have to go through 74 witnesses in a 2.5-month trial. Here's a picture of her Lexus backing into John O'Keefe. So some kind of a statement was made at some point. I went back and listened to that video that Michael Morrissey himself released before trial 1, back before the holidays in 2023. He was furious, mad as a wet hen, as I said before, that there was alleged harassment of witnesses. And he actually released a video, which he himself said, this is very unusual. I've never done anything like this before. But he released a video, very acrimonious video, telling people to stop their going after the witnesses. Because I thought maybe it was in there, and I recalled wrong. It was not in there. There was no promise in that video. But it just seems to me that A, if there's a video, where is it? I don't think it exists. And B, what about all of the ring cameras and security cameras in that neighborhood? Where are they? I mean, in this day and age, 2022, when this happened, those things are everywhere, aren't they?
I know that me and both my neighbors have them. Each neighbor on each side has a camera, and one of them has a camera in the back. And it's actually kind of great because I walk behind their house because we're connected, and then the light goes on, and I'm like, wow, there's a light back here. Thank you, neighbor. But I agree. I have everything. And it's funny because you'll have stuff that you didn't even realize. You'll look back a week later and you'll be checking your camera footage and you'll just be happening scrolling. It's like, oh, what's that? And you'll see something. So it is surprising that you're right, that they haven't had any footage. They said they were going to have the footage. And there's just so many, like, I don't know, because it's like not even just the houses. It's just like you think about how many businesses and cities and just, I mean, this was a residential area, but it almost feels like everywhere you go, you're being watched now. So that is a great point you bring up.
And this is an upper middle class, well-to-do neighborhood. And those are the kind of people that want to protect what they have. Those are the kind of people that have ring cameras. And it had been said that there was video where instead of just, taking pot shots at Karenread's case, why aren't they bringing in, more positive evidence to substantiate their own case? But so I don't know. That's the most recent motion, and it was filed, January 2nd. Isn't that interesting?
No, wait, what a way to start out the new year.
Yeah.
They were thinking about that one.
So we have some great comments this week. Do you want to start out with our great comments on this case?
Yeah, so this one is from Caro 1057. As an ex-ortho nurse who worked in emergency, I'm very familiar with what MVA accidents look like. John did not appear to look like this without shoulder pelvic limb breakages, and the vehicle clearly did not look like it was in MVA. And that is something that a lot of people have said about the different injuries. Some people are like, oh my God, those are definitely car injuries. Oh my goodness, they're not. But there's a lot of back and forth. And it seems like a lot of people have their doubts.
Yeah. I think of the comments that we got, we did get some negative comments, but most of the comments that we got were, that's so obvious that it's a dog bite. I had a dog bite and it looked just like that. So, I would have to say that if our commenters were on the jury, the majority, not all, but the majority would say, yeah, that those were not motor vehicle accident injuries. Those were dog bite injuries. So the next one kind of raises a point we just talked about from DF 224. I have seen the house and neighborhood where the alleged Read accident happened. There are ring cameras that were never used. So, good point. Good point.
Yeah, well, that's the thing. It's just like if they had the ring cameras to show, they would have shown it. Cameron L15K. Even if they could say that the scratches were caused by taillight, they still have to overcome the reasonable doubt that ARCA experts opined that a car did not hit J.O. I don't believe that even if they could prove a taillight did it, that it improves Karen did it, seeing as there was also another car reported on scene, and Higgins hightailed it out of the scene in his truck early in the night around the time of the accident.
Yeah, that's a really good point. And again, because the ARCA experts were so important, they were not beholden to either side. Neither side paid them. They were brought in by the FBI. They were very credible. They said that there was not a car strike. So that will be, in my estimation, that will be Mr. Brennan's next target. He's already gone after the dog bite expert. In this episode, we have talked about how he's going after the forensics guy, and now that'll be next, in my estimation.
And you know what? I think it's a fair guess to have.
Okay, we've said that the world is watching. This is a list of the countries from which we've gotten comments, and there are 5 new ones this week. 5: Iceland, Switzerland, Bahrain, Greece, and Portugal, all new.
Yeah, thank you guys. It is so fun to see this list growth. We appreciate it. Feels unreal almost having people from all over the world watching us. It's so fun to be able to add more countries to this list, and we appreciate all the comments you guys leave us, all the likes, all the subscriptions. It's been a crazy year, and we hit 10,000, and now we're already at 11,000. It feels so crazy, so we appreciate that a lot.
Yeah, and people will got a couple of people that said Mexico and Canada. Well, they're on the list. They're all the way at the bottom, all the way in the 4th column towards the bottom. But people, like to point out that they're from Canada. They're following it. I got one from Baja, California, which is part of Mexico. So yeah, people that are from these countries will say, "Do you have my country on the list? Do you have my country on the list?" Well, there they are. So take a look. If you're not on that, well, anybody comment, please. But if you're not on that list, let us know. All right. I always put you on the spot and ask you if you have any closing thoughts.
I mean, the only closing thoughts I really have is that this whole thing seems a little. In a world where we have so much access to technology, you would think that being able to agree on this would be the baseline. It's like we have Safari, whatever search accounts they're using on Safari, whatever search engine is being used on Safari. You have the browser history, and then now you have this whole other software that you're saying is only half credible. There's a reason that I'm not an expert witness, but at the same time I'm surprised, because if I wanted to go snooping around, whenever I go snooping around, I can usually find what I want to find. Someone was being really inappropriate to women on the internet, and I was easily able to find his mom and send her his profile. So
really?
like
Wow.
I'm just saying, like, information is very easily accessible, whether you guys realize it or not. So one, definitely be careful about what you're putting out there, and what you're searching up on your phone and everything that you're doing on your device, because if it's digital, it's being tracked. They need to get a consensus on this.
I imagine that my closing thought is that the defense team will strike back. I mean, when the Commonwealth filed their motions against Dr. Russell, Attorney Alisi spent an entire day, almost an entire day, questioning Dr. Russell on the stand. And she proved to a lot of people's satisfaction that, yes, she is an expert. She spent all those years in the emergency room. She was a police officer. And yes, she does know her stuff. Brennan's not done with her. We'll probably talk about that in a future episode, because her second day is coming up. But so my guess is that, although the motion claiming that Richard Green was debunked, it was debunked. I hate that word. I mean, I think it's a word that kids use on the internet. If you say something that somebody doesn't like, it's been debunked. So I question the use of that word in an actual legal filing. But what I was going to say is, my guess is that the Karenread defense will come back and strike out at that motion, and Mr. Green will have the opportunity to defend himself, and he will be an expert. If not, they'll get 5 new experts.
Exactly. Yeah. That's the thing is there's gotta be some baseline on facts that we can agree on. But now all of our comments are gonna say that we've been debunked.
You've been debunked. Speaking of debunked, be kind, be professional. This last week, I don't know, people's tensions were high, and I did have to, and I make no bones about the fact that we do delete comments. If you're nasty, if you say nasty things about us, or if you say nasty things about a sitting judge or about, we have to remain professional. We have to remain amicable. I know I've said things that, about some people that were involved in this motion today, but we really want you to not call names, but tell us why you feel that. Tell us why you feel that some of the rulings in the case haven't gone the proper way. Tell us why you think that this motion we talked about today is not a good motion. But just don't sit there and call names, because you're just going to waste your time, because I'm going to delete it. Be kind. Be nice. Thank you for joining us, and have a great weekend. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.